But the one downside is that there are two downsides, I think. One downside is that now the government can ask companies to take down content, or any other intermediary, not just a company, an individual as well. But also, I think that when there is something that, there's another downside to this, something that should be legitimately taken down, like, so for instance, with child pornography, intermediaries basically themselves take it down, actively so, whether it's reported or not, and this is true around the world. So intermediaries anyway sort of make particular decisions, right? Like even though they're private companies or private individuals, they will decide, is this something that is just a family picture of a kid running around, or is this child pornography, you know? So these are sort of fine determinations that private actors have taken upon themselves, but are also forced to make. In the same way, there was an alternative formulation that we did put across to the court, and that alternative formulation was that if in a system of notice and counter notice, if it is blatantly obvious that there is something that violates the law, then then the intermediary can make an interim decision on whether the content gets taken down or not, preferably with an external actor, like in the Vishakha cases. And then after that, that can be challenged in court. But once the intermediary applies their mind, they receive a safe harbor, and all it does is that it decides that decision-making process within the intermediary company or by the intermediary individual. It decides who goes to court, who has the burden to get a lawyer, and in civil litigation, very rarely, in very few cases do you get legal aid. You know, so who has the burden of going to court? It's not that this formulation doesn't have issues, right? Like, so for example, your intermediary may be one person who's based in Norway, but whose website is accessible in India and who doesn't know anything about Indian law, you know? But this is one of the alternative formulations that we did put across. So this is something to look out for. And this can perhaps be dealt with in sort of these multi-stakeholder conversations and that are being had increasingly, and, you know, terms of service, sort of voluntary commitments of various sorts. Now, what was it that worked here? I think there were a number of things, right? Like, I think we didn't self-edit, for instance. You know, we challenged, ours was a very comprehensive petition, and we challenged Section 66A, yes, but we also sort of wanted natural justice and constitutionality read into the website blocking rules, and we also were challenging the intermediary rules. Now, this seems like a lot, right? Like to go to court and say that, look, this act passed by Parliament, there's problem A, problem B, problem C, and can you like basically strike down and read various things into all of this? But I think we went with the principle of it, which is that if this is wrong, and if this is constitutional, then it must be challenged. And let us not self-edit. And if the court does not want to interfere, let the court not interfere. We will make our arguments, we will do our work, we will build our coalitions, and we will sort of do our best to hit the bullseye. And then after that, let the court decide. I think the second thing that worked very well was the collaboration. When I first came into this case in about 2011, 2012, there were sort of various parts of, you know, there were various aspects of tech that I didn't quite get, like how it worked, for instance, you know? And I basically set about educating myself and getting help. At that point, you know, sort of I and the colleague who was been assisting me sort of extremely well in this case, Apar Gupta, you know, basically reached out to the Center for Internet and Society, you know, Pranesh Prakash and, you know, the wonderful Sunil Abraham, and also Chinmay Arun and at NLU Delhi and, you know, Sarvajit's team. Also, you know, Lawrence Liang and others. Well, Lawrence isn't a tech person so much, but he's more a free speech person. But, you know, and I set about kind of educating myself on how the tech worked. That's when I got on Twitter. I mean, otherwise, it just seemed like way too much noise. But the thing is, Twitter is a bit like Hotel California, right? Like, you can check out, but you can never leave. But I think actually going through the process oneself is, that's when, I sort of realized the sort of differences, for instance, between takedown and blocking, So for those of you who are sort of not aware, takedown is basically if the whole content is taken down for the whole world, and blocking is essentially, and these are sort of broad definitions, but blocking is if particular types of content is just blocked for your country. And I mean, it's interesting. It just takes a lot of hard work, a lot of humility, and a lot of consultation, to become an expert. And I would say that in the tech field and the tech law field in particular, that it's important, I think, for women to not hesitate to enter this field. I think sometimes there are artificial barriers that are created. There's a certain amount of mansplaining, in this field, which I've surprisingly never got in my 15 years of practice in arguing other constitutional cases. But it's important it's very important to overcome that, right? Also, in court, the Shreya Singhal case was argued by Soli Sorabji. PUCL was argued by Sanjay Parekh and by me. There was a case for the Intermediaries Association that was argued by Sai Krishna. Sajan Povaiya was for the MP who speaks out a lot about free speech. There was one more. There was Sham Diwan also, who was arguing for mouth shut. Now, there was a lot of collaboration between all of us. For example, when there was a point being argued that looked like it was, let's say somebody was going before us, that was sort of setting the mind of the judge. And sometimes by the time it's your turn to argue, the judge on a particular point has already sort of asked the questions and has already kind of decided, what he or she thinks. But at that point, we would hand over those judgments. We would sort of assist in terms of answering questions. We would sort of hand over particular formulations of the law. Also, there was, it was very fluid in that way. I mean, I think the eye was very much on the win, right? Because the win is important. That yes, you can do your best and, all that is very well, but I think winning and having that killer instinct is extremely important. And in many cases, the interesting thing is that it is the killer instinct that requires you to collaborate, right? That requires you to put your ego aside. And that requires you, in the interests of, what you believe in. But also just the brief you have, it's a private case if it's for a company, right? To just make sure that you are keeping your eye on the ball. Now, there are a number of challenges ahead. And for those of you who are lawyers, and for those of you who are law students, and for those of you who are legal policy makers, I think that this judgment I would urge you to read this judgment, and I would urge you to read it in detail. Because one thing that this judgment has, and the one thing that it brings, is courage. It is a two-judge bench that has basically overhauled the face of online speech in India and the face of speech, constitutional speech in general. There are a number of laws that we have that are problematic. We have Section 124A on sedition, which at its lowest threshold, if you excite disaffection against the government, right, can send you to jail. Now, the Bombay High Court has recently done an excellent job in the Seem Trivedi case of limiting that. However, the Supreme Court, unfortunately, in a constitutional bench, failed to strike it down, right? This is a bench of two judges. There is the tyranny, when we look at challenges, there is the tyranny of the crowd. The crowd in human mobs and online media. There is the tyranny of corporate cross-ownership that limits the kind of news that we get and that shapes sometimes the kind of news that we get. It's the kind of issue that we are discussing in the net neutrality debate, and the issue that people have understood very well in the net neutrality debate, which is that, for example, if I am the ISP, the internet service provider, and I own the pipes, like you basically subscribe to my plan, then I should not decide that what content you get. You should be able to access whatever content there is. But we forget this principle when we are looking at particular TV channels and their cross-ownership with various other industries. And we forget, when we see the news, very often on television. I used to be a television journalist, actually, for a year when I was 19 years old. And sometimes in television, people think that seeing is believing, And you think, oh, TV pe dekha tha. But you don't quite apply the filter that you apply in the rest of your critical life. And sort of see what is being reported, what as importantly is not being reported. Why is this thing being reported in the way it is? I think another challenge there is the singular idea of national interest that is sought to be propagated through governmental crackdowns and through various laws, including the Foreign Contributions Regulations Act. Our constitution is our own, but among the contributions of this judgment is its comparison of our free speech, the structure of our free speech regime, to the US regime. And the intellectual confidence and leadership by which this bench drew on ideas that may have been either cited in argument or in written submissions, of course in the precedent of the courts, of our courts, but also in the precedent of other courts, including the US court, the US Supreme Court. Justice Nariman told us in court that this paragraph that I'm going to read is a particular favorite of his. It is in tribute to the bench that laid down this extremely important judgment. And I'm going to end with this. This is from Whitney versus California, and this is Justice Brandeis in his famous concurring judgment. This is cited with approval in Shreya Singhal versus the Union of India. Those who won our independence believed that the final end of the state was to make men free to develop their faculties, and that in its government the deliberative forces should prevail over the arbitrary. They valued liberty both as an end and as a means. They believed liberty to be the secret of happiness and courage to be the secret of liberty. They believe that freedom to think as you will and to speak as you think are means indispensable to the discovery and spread of political truth. That without free speech and assembly, discussion would be futile. That with them, discussion affords ordinarily adequate protection against the dissemination of noxious doctrine. That the greatest menace to freedom is an inert people. That public discussion is a political duty. And that this should be a fundamental principle of the American government. They recognized the risks to which all human institutions are subject, but they knew that order cannot be secured merely through fear or punishment of its infraction. That it is hazardous to discourage thought, hope, and imagination, that fear breeds repression, that repression breeds hate, that hate menaces stable government, and that the path of safety lies in the opportunity to discuss freely supposed grievances and proposed remedies, and that the fitting remedy for evil counsels is good ones. Believing in the power of reason as applied through public discussion, they eschewed silence coerced by law, the argument of force in its worst form. Recognizing the occasional tyrannies of governing majorities, they amended the Constitution so that free speech and assembly should be guaranteed. I think the laws that we've inherited are from a colonial government that did not have an interest in free speech, that did not have an interest in hearing what our subjects had to say. Many of the laws that suppress free speech in India are inherited from that source and are in the IPC of 1860. Many of these, I believe, need to be read down or need to be struck down. Also, we have increasingly the push towards unitary thought in public life. We have, for instance, lists released by the censor board, which say things like violence against women, and I quote, will not be permitted in English, but it is fine in Hindi. We are told that the word Bombay is something that is not permissible. We are told that the lesbian must be bleeped out of a film. Now, it's a good time to be a lawyer, and it's a good time to be a policy person, because there's a lot of work to be done. And I think the greatest contribution of this judgment is that it gives a very clear signal of what our Constitution is, what our rights are as a polity, but also what each one of us, whether we are lawyers, whether we are journalists, whether we are policy people, or whether we are just people on Twitter, what we need to do about it. Thank you.
The Firm, India's only show on corporate law, tax and audit matters.